Good afternoon or early evening, everyone. You've had the great benefit of listening to some of the leading experts in all sectors of what might be described as the technology and construction court world, albeit the world, not just England and Wales. And I'm sorry to say that you now have to listen to me, rather than going straight to what would be, no doubt, a well-deserved drink. But you'd be pleased also, I hope to know, that I don't propose to recapitulate on what others, who are far better and far more involved than me, have said throughout the day. And I also don't intend to overrun my 15 minutes of fame, as the last thing we all need at the end of a day in a room filled with lawyers, quantity surveyors, and experts generally, is a delay and disruption claim. So I hope it might assist if I set out some thoughts, this being the conference of the UK Adjudicators, about how to produce an enforceable decision as an adjudicator, and then, or rather how to avoid producing an unenforceable decision, and then say a little about the enforcement process in the courts in England and Wales. And I apologise in advance if I'm teaching most of you what you already know, but I am bound to say that in my time as a barrister, an adjudicator, and occasionally a judge in the TCC, I do still see some things which, quite simply, should not be happening at all. Now, please note that what I'm going to say is obviously my personal view. And also, I'm speaking, as I'm sure we have been doing all day, under the Chatham House rules, which reminds me of a story I was told about a journalist who was, quite a young journalist, was interviewing a minister of state. And he told her at the beginning of the interview that it was, of course, under Chatham House rules. And she said, "Yes, of course, Minister, of course it is." And they then had a full and frank discussion. The next morning, everything that the minister had said was on the front page of the newspaper. So he rang the journalist up. He said, "What are you doing? I told you that we were talking under Chatham House rules, and you said that you knew that." And she said, "Well, I did know that, but I just thought that meant no smoking." It doesn't. Anyway, as the talent show host would say, in no particular order, I have 5 points to make about enforceable awards and how to achieve them. First of all, this is a fairly basic point, but I'm afraid I still have to make it. Make sure that when you're producing an award, you do so within the time allowed, and that you record any extensions of time agreed by the parties in your award. If you let time slip, the whole process and all of the costs of that process will be wasted. And by far the worst thing that will happen is that you won't get paid. Secondly, when you're drafting the award, set out the chronology of what happened in the award, in the process of the adjudication. I know it's tedious, but it's really helpful. And in addition, set out all the submissions that you've received from each party in time, and confirm, as will of course be the case, that you have read them all and that you have taken account of everything they've said. Third, make findings on the issues that the parties have raised, not your own ideas. Now, I know that adjudication allows decision makers to inquire, etc., and consider matters. But natural justice clearly requires parties to be allowed to comment on new issues, and especially to comment on them before they read them in an award. And in my personal view, frankly, where both parties are, particularly where both parties have professional representation, it just looks dreadful if the adjudicator comes up with a point which favours one of those two parties. So that's my third point. I'll come back to that in my fifth point. Now, be clear. Fourth, be clear about what precisely it is that you are deciding. by reference to the relief set out in the notice of adjudication, which is normally repeated, hopefully identically, in the referral. Because if you produce a decision which is unclear, it may not be capable of being enforced. And we all know about decisions where decisions have been taken, for example, on money claims, but it's not entirely clear whether that includes an order that the money is paid from one party to another. Of course it should be clear, of course it obviously does, but you don't let that issue even arise, because it's not really fair on either of the parties, frankly. And then, fifthly, please bear in mind that when you're writing an award, what the parties want to know is why they've won, but more importantly than that, parties want to know why they've lost. And it's absolutely vital, in my view, to explain why you have rejected one party's position in straightforward and simple terms. Otherwise, the losing party may well come away from the process thinking that they didn't have a fair crack of the whip, even if, as is overwhelmingly the case, they did. And if, first of all, it's not fair to the parties in that case, and second of all, if part of your career is being an adjudicator, you really don't want to get a reputation for dealing in an offhand manner or a prejudged manner, God forbid, with parties in adjudication, because eventually people will talk and you may find that you are appointed less often. So those, I hope I'll be forgiven for giving you those 5 points, which I think are important when you are sitting as an adjudicator, and also probably important when you're acting as party representatives or even are a party, what you should expect to get from an award. Finally, I think I've got about 4 minutes left. How does the enforcement process work? Well, I know that many of you may well be familiar with the enforcement process in England and Wales, and for that matter, similar in Northern Ireland. I can't, I'm afraid, speak about the Scottish process with any expertise at all, although I do understand it's not vastly different from the English process. But I hope that a quick thumbnail sketch might be useful. So the TCC in England and Wales, a commercial hub in Belfast, have a well-settled processes for the speedy resolution of enforcement applications. And they are heard by way of summary judgment applications. That the first ever case on enforcement decided that they should be heard by summary judgment. As you know, the Act and the scheme don't say how adjudication is to be enforced at all. The application for summary judgment is made for summary judgment and to abridge time for serving a summary judgment application, because otherwise you would have to wait at least 14 days to get an acknowledgement of service, and then a bit longer. But what normally happens is acknowledgements are required within 3 or 4 days. And they're usually granted and directions are given on paper. And the hearings tend to be heard within 4 to 6 weeks of the claim being made, which is roughly equivalent to the sort of time that most adjudications finish. Obviously, they're supposed to be 28 days from the referral, but sometimes they're not. The hearings are now held, usually remotely, so that although your judge is notionally in London or Manchester or Birmingham, they're probably at home or they're in the court, but no one else is. The parties are wherever the parties want to be when they're making their submissions. And they last for about they're normally fixed for 2 hours or sometimes for a full day. And you usually get judgment on the day, but if not on the day, shortly thereafter. So that's consistent with trying to achieve what adjudication is trying to achieve, which is a quick result. There's no point having a 28-day result in a smash and grab adjudication and then it taking 6 months for you to get a court to order the payment. You might as well not have bothered. So the courts are alive to that, and I would suggest, again, it's a personal view, that they actually do that pretty well, frankly. And then the court's approach, in my last 2 minutes, is also, I would say, well settled. And in a nutshell, courts are very keen to enforce adjudicators' awards. Pay now, argue later is the constant theme of enforcement judgment. And unless the court considers one of the limited grounds of challenge, namely jurisdiction grounds, or natural justice are even strongly arguable, awards will be enforced. And it seems to me to be key to understanding why courts are so keen to enforce is understanding that, of course, adjudication is not a final determination of the party's rights, unless, of course, time passes and it becomes final, as in the NEC contracts, or unless the parties agree that the adjudication should be determinative. So it follows from that that awards which have errors in them are enforced, constantly enforced, and indeed errors are largely regarded by judges as being completely irrelevant to whether you would enforce an award or not. Now that sounds counterintuitive. How could a judge who's interested in what's right and what's not enforce an award with an error in it? But it's precisely because what they're enforcing is a temporary decision, not a final decision, that provided the awards are otherwise enforceable, the courts are not interested in the merits of the overall dispute.